In this video, we're going to be talking about the constitution of a trust, and this will form part of 2 or 3 different parts. So once you finish this one, I'd recommend you check out the other parts to the constitution of a trust so that you've got the whole picture. So let's begin. Capacity of the settlor. Now, the person creating the trust must have the capacity to do so, and capacity is defined by the Mental Capacity Act 2005 as the ability to understand and retain information relating to the decision, to weigh it in the balance when making a decision, and to communicate the decision. There is a presumption of capacity, and any person wishing to have a trust set aside on the grounds of incapacity must provide positive evidence that the settlor lacked capacity. So a person is presumed to have mental capacity under the Mental Capacity Act unless the contrary is established, as seen in Section 1, subsection 2 of the Mental Capacity Act 2005. Capacity issues may affect the ability of a person to make a will or a gift or to create a trust. In all decisions, the level of capacity required depends upon the seriousness of the decision. So, for example, the level of capacity required for a person giving £5 to a charity collector would be much lower than the level required to decide to dispose of one's estate by will or to sell or give away one's home. So, in the case of a lifetime gift, it seems that the test varies according to the size of the gift and its relationship to the sum of the assets owned by the donor. And this is confirmed by the Rebini case here. And in this case, a mother who was suffering from senile dementia made a gift of her home, the only substantial asset of her estate, to one daughter, Valerie, who stayed at the home to look after her mother for many years. But this had the effect of virtually disinheriting the 2 married children. And it was said, the degree of understanding required in respect of any transaction is relative to the particular transaction which it is to effect. In the case of a will, the degree required is always high. In the case of a contract, a deed made for consideration or a gift inter vivos, whether by deed or otherwise, the degree required varies with the circumstances of the transaction. Thus, at one extreme, if the subject matter and the value of the gift are trivial in relation to the donor's other assets, a low degree of understanding will suffice. But at the other, if its effect is to dispose of the donor's only assets of value, and thus for practical purposes to preempt the devolution of his estate under his will or intestacy, then the degree of understanding required is as high as that required for a will, and the donor must understand the claim of all potential donees and the extent of the property to be disposed of. So it was held that Mrs. Beanie's gift to Valerie was void because she was not capable of understanding the conflicting claims of her children. If a person lacks capacity, the Court of Protection has wide powers to deal with their property in the person's best interest. This may include making provisions for dependents and dealing with assets in tax-efficient ways, either of which may be reason for creating a trust. So the Court of Protection can take control of property and dispose of it in that person's best interest, including doing so in a tax-efficient way. So the problems in Rebini can be avoided if an application is made to the Court of Protection. Under the Mental Capacity Act of 2005, the Court of Protection has wide powers of dealing with the property affairs of a person who lacks capacity to make the decision in question. So, capacity of the settlor is one of the things that we need when we're creating a trust, and there are ways of sort of circumventing this problem by making an application to the Court of Protection. Children aged under 18 can, if they have capacity, as we've just seen, create a valid trust, but the trust is voidable. The child may repudiate, in other words, abandon the trust either under the age of 18 or within a reasonable time of reaching that age. So in Carter and Edwards, reasonableness was the issue in this case. They left it too long, 4.5 years, after reaching the age of 18 to revoke the trust. And also note that a child cannot hold a legal estate in land, and that can be seen under Section 1, subsection 6 of the Law of Property Act 1925. If a child becomes entitled to a freehold or leasehold, the land is held in trust for him, and that is seen in Tolata of 1996, Schedule 1, Paragraph 1. I understand there's a lot of statutes and acts and stuff, but just understand that this present stage, that one, you need capacity, and also two, if you're a child and have capacity, you can create a valid trust, but that trust is voidable. That's the most important thing to get so far. So what are the formalities? Now, we have a requirement of writing, and a declaration of trust does not need to be made in writing unless it is a trust of land. Okay, writing may be required to transfer legal ownership to the trustee. So in general, trusts don't require a specific formality such as in writing or in deed, so they can be made orally as long as they are not of land. Okay, so with the creation of trust of land, evidenced in writing is required. Okay, all testamentary trusts must be in writing too, signed by the testator and attested by two witnesses as required by the Wills Act of 1837, Section 9. Okay. The requirement is that the settlor intended to create a trust. A written declaration may therefore be better evidence than an oral declaration, but other than that, there is, as in contract, no requirement for the intention to be expressed in writing. So the basic rule is that a settlor may create a trust by manifesting an intention to create it. So although the trust can be created orally, it will be easier to show evidence of intention if it is written. It is necessary, however, to observe literally every word of the basic rule. The intention must be to create a trust. A general intention to benefit someone will not suffice. And in Paul and Constance, a bank account was held in the name of a man, and he said to his mistress that he holds the money in the account for them both jointly. He said, "The money is as much yours as it is mine," and the court upheld that there had been a creation of an express trust despite it only being made orally. Legal ownership of some forms of property can only be transferred in writing or by some other formal process. So with a trust, you can transfer the beneficial equitable interest in the property to a beneficiary, or the legal title in the property to a trustee, or both. When transferring the legal ownership of some forms of property, this transfer can only be effected by writing or some other formal process, so not orally. And we've got these cases here. So we've got like land must be transferred by deed. That's section 52 of the Law of Property Act 1925, which you would have seen in my land law videos. And the requirements of the Land Registration Act must be observed. If you are dealing with shares, they must be transferred by the form of transfer laid down by the Companies Act 2006, together with the stock transfer form prescribed by the Stock Transfer Act of 1963. And copyright must be transferred by writing. That's section 90 of the Copyright Design and Patents Act 1988. So in other words, intellectual property must be transferred by writing. And then finally, bills of exchange must be transferred by endorsement. So that's section 31 of the Bills of Exchange Act 1882. So in other words, signed on the form itself. But with other things, the legal title of that thing can be transferred without any sort of writing or similar formal process. In other words, it can be done orally too. So these are just more specific circumstances where there will need some more specific formal processes. So let's look at land, okay? Now, we've got the Law of Property Act, section 53, and this provides that the transactions for the creation or disposition of an interest, either the beneficial or legal interest, in land must be in writing and signed, and that's section 53, subsection 1a. So equitable interest in land must be created by signed writing, and if you want to transfer legal title to someone, you you need a deed following the requirements of the Miscellaneous Provisions Act, Section 2. And this was all should have been covered in your land law classes. And if you haven't studied land law or don't understand this, then check out my land law videos where I do cover all of this sort of content about the formality requirements of creating or disposing of an interest in land. So firstly, we've got that it must be writing and signed. We also have that the trust of land must be evidenced in writing and signed. So with an express trust of land, there must be evidence of the trust's existence should someone choose to enforce it. And this does not necessarily mean it needs to be in existence at the trust creation. So when the trust is created, it can be done orally so long as it is later proved in writing. The writing is required as evidence of intention. The declaration itself need not be in writing, and failure to comply with this requirement renders the trust unenforceable and void. And also that any disposition of an existing or subsisting equitable interest must be in writing and signed. So this says if you are the owner of the beneficial interest, you can transfer it to someone else, just like with any other property interest. So if you are the beneficiary under a trust, you can give or sell your interest to another person. But if you want to do that, you must do so in writing. And this section applies bizarrely to both land and personal property. And this has been interpreted to apply to all types of property, despite being in the Law of Property Act itself. So it's a bit strange. That doesn't just apply to land, it can apply to personal property too. And the word subsisting means it's subsisting in the sense that the legal and equitable ownership have been separated. And if it is not writing and signed, then it will be void. Okay. And these provisions do not affect implied, resulting, or constructive trusts. So the provisions of Section 53 only apply to express trusts. So there is no writing needed for implied, resulting, or constructive trusts, as these arise from the operation of the law. And we said that the aim of the 1925 Act, which was part of the complete revision of land law in 1925, is to ensure certainty and to prevent fraud. And the statute derives from the Statutes of Fraud, which was enacted in 1677, followed by the Restoration. And we have this sort of language here from the Statute of Frauds in 1679. And if you were to read it through, I'm not going to, but if you want to read it through, then just pause the video and have a little look. But you can see that the language used is pretty similar to the Law of Property Act 1925, but it's in a more archaic language, as you would expect. And in other words, most of the formalities relating to the creation and constitution of trusts are based on this 1677 Statute of Frauds, which was concerned to prevent fraudulent claims by people asserting rights to property to which they had no genuine rights. The main problem identified by this legislation was the lack of evidence as to which a person owned which rights, unless claimants were required to produce written evidence of their entitlements before their claim would be entertained by the courts. And this approach was the basis for formalities as to the declaration of trust over land, conveyance of rights in land, dispossessions of equitable interests, and the proper creation of wills. So have a little look at that, but don't get too bogged down. This is a bit more of like the background to, what form the basis of these particular formalities. Then in section 53, subsection 1b, it says a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust or by his will. And these requirements relate to express trust only. Constructive and resulting trust over land may arise when there is no written declaration of trust. So manifested and proved does not necessarily mean that the declaration itself should be in writing. There may be circumstances in which the written and signed document which proves the trust without actually making it the declaration. So the writing is required as evidence of intention. The declaration itself need not be in writing. Wills also have to be in writing and witnessed by two people. That's the Wills Act of 1837. So a testamentary trust of land will comply with the requirements of writing. So witnesses can't be beneficiaries or married to beneficiaries under the will. For a will to be valid, these requirements must be fulfilled. And fulfilling these requirements will fulfill Section 53, subsection 1b of the Law of Property Act 1925. So Section 53 1b means that if a person conveys legal title to real property to another, which must be in writing, with an oral declaration of trust, the trust is not binding on the legal owner. They take the property absolutely. So if X legally transfers the legal title to another person Y, in other words, such as by deed, but orally says that there should be a trust. So X says that although Y has the legal interest, he should hold that land on trust for B. That trust will not be binding, and Y will continue to hold that land absolutely. So in other words, will retain the legal and beneficial interest. And I'm going to quickly introduce an equitable maxim because I think it's important for us to understand this. So equity will not allow a statute to be used as an engine of fraud. So in other words, what this equitable maxim means is that a person will be precluded from relying on her common law or statutory rights, where to do so would enable her to carry out a fraud on another person. And if you don't understand equitable maxims, I did actually cover quite a few different equitable maxims in my introductory videos on trusts, so go check those out if you don't understand what an equitable maxim is. But this is one of those situations where an equitable maxim will apply. This principle cuts to the very heart of the trust concept as an essentially equitable doctrine. If a trustee, the legal owner of property, were able to rely on common law rights to the exclusion of all others, this would enable her to misuse the property held on trust for the beneficiary. For example, when Daniel is trustee of the land held on trust for Yasmin and Zina, Daniel is able as legal owner to take out a mortgage over the land. And suppose then that Daniel purports to keep the loan money raised by way of mortgage for his own benefit and refuses to make any of the repayments. The result would be that the mortgagee would repossess the land to discharge the loan. And according to the common law, the mortgager, Daniel, is the owner of the loan property. However, equity will prevent Daniel from relying on that common law title to prevent Yasmin and Zina from asserting any rights over the mortgage monies on the basis that the common law would otherwise be used as an engine of fraud by Daniel. Therefore, this principle is at the very heart of preventing trustees from misusing trust property and is also primarily concerned with imposing trust obligations on fraudsters. So, where a person is fraudulently relying on Section 53, subsection 1b to deny a trust in land, equity will not allow the person to retain the beneficial ownership of the land or the interest in land. So there are cases where people come into possession of property which the transfer intended to be held on trust, and the person having received the property either sold it onto a third party or denied the transferor's beneficial interest. So in order to uphold the trust, the transferor will have to take that person to court. So if the person is fraudulently trying to keep or assert a beneficial interest in land that she acquired subjected to a trust, the court of equity will not allow that to happen, and it will uphold the oral trust. So even though normally under statute an oral declaration of trust will not be upheld, to prevent the perpetration of fraud, the court will sometimes uphold an oral trust, as seen in the Boosted case here. And in this case, the plaintiff mortgaged her. Well, really, it's probably the clearest, before I go into that, it's the clearest exposition of this rule that equity will not allow a statute to be used as an engine of fraud. So, and it's really quite an interesting case. So the claimant was a mortgager of land, and the land was sold by the mortgager to the defendant. The defendant had already agreed to hold the property on trust for the claimant, the mortgager, subject to the repayment to the defendant of the purchase price. In other words, so long as the defendant would get his money back for the purchase of land from the mortgager, he agreed to hold the land on trust for the claimant. However, the defendant sold the land at a higher price to a third-party purchaser, but did not then account for the surplus in the sale proceedings to the claimant, the mortgager. The defendant then became bankrupt, and the issue arose whether or not the claimant could assert any rights in the money which ought to have been paid to him by the defendant, but which had not been so paid. It was held that it is a fraud on the part of the person to whom the land is conveyed as a trustee and who knows it was so conveyed to deny the trust and claim the land himself. Here, parole or oral evidence was used to prove that the land was conveyed upon trust when the defendant agreed that the property would be held on trust for the claimant. So although there had not been a formal declaration of trust over the land, the court was determined to prevent a situation in which the defendant would have been able to avoid the parties' common understanding that the land was to have been held on trust for the claimant. Therefore, the court deemed there to have been a valid trust to avoid the perpetration of a fraud. The Court of Appeal thus refused to allow the statute of frauds to prevent the proof of a fraud. So that is a nice little case that explains how this equitable maxim will operate. It is a moot point whether the trust established is an express trust or resulting or constructive trust. So the principle of this decision is that in the case of fraud, oral evidence is admissible to establish the trust in spite of the statute. So on this basis, the trust is express, although modern cases have tended to treat trusts established in this way as constructive. And we've also got Hodgson and Marks, and in this case, Mrs. Hodgson transferred her house to her lodger, someone who lived alongside her, Mr. Evans, on the basis that she would remain the beneficial owner of the house, of the whole. They both continued to live in the house under the same arrangements with regard to rent and payment of bills. He held the legal title as bare trustee for her. A bare trust is one where the trustee holds the property for the benefit of an adult absolutely, that is without any other interest or discretion. He then, in breach of trust, sold the house to Mr. and Mrs. Marks. When the Marks came to view the property, they saw Mrs. Hodgson coming up the path, but did not make any inquiry as to who she was or if she had any interest in the house, assuming she was Mr. Evans's wife. The court ultimately held that despite the statute showing them no legal declaration, the court ultimately held that despite the statute showing that no legal declaration of trust had been made, they would uphold the oral trust as to deny the widow's interest in the house would be fraudulent. So that is probably it for this video, and we've really looked at a very quick and probably quite overwhelming introduction into the formalities and in terms of the constitution of a trust. There is still some more to talk about. Specifically in the next videos, I'm going to be talking about the Law of Property Act 1925 section 53 subsection 1c and the disposition of an equitable interest. And I'm going to dive into, a couple of key cases that I think we're going to have to look at, and that'll probably be a video or two on like Van der Velde and Oftred and stuff like that. So I'm going to leave it there for the minute, and if you have any questions about this video, then please leave a comment below. I'm trying hard to make sure that you can understand it as well as you can, but sometimes the law can be a little bit heavy and a bit difficult to understand, so I totally understand if there are parts of this video that you haven't understood as well as you may have wanted first time round. So just drop a comment below and I'll get straight back to you. Make sure you subscribe to this channel, and I shall see you next time. Thank you very much for watching.